of our program. We're going to turn now to the Troy Davis case. It's in Georgia now, and it's a really very important case. We may be seeing Georgia send a innocent man to death row, and it is something that we need to make all of us in this community aware of, that the battle around the issue of the death penalty is a very important one. And we did, in fact, contact the prosecutor's office and ask them to join us. They sent a statement instead and declined to be part of this discussion. As I understand it, declined to be part of many discussions. And at the moment, we are about to introduce you to Martina Correia, who is Troy Davis' sister. She's part of the National Steering. She is his National Steering Committee chair for Amnesty International's USA's program to abolish the death penalty, and Amnesty International State Death Penalty Abolitionist coordinator in Georgia. As I said, the sister of Troy Davis. And Deirdre O'Connor is professor of law at the Emory Law School and director of the Innocence Matters Project. And Martina Correia and Deirdre O'Connor, welcome. Good to have you both with us.
Thank you for having us. Thank you. Thank you for having us.
It's a pleasure, and thank you so much for joining us here at the last minute. Join us here at 410-319-8888 and to join this conversation. I was reading, I spent a long time today for the first time reading Spencer Lawton Jr.'s, the district attorney's for Eastern Judicial Circuit of Georgia's comments about Taseman's response to the denial of a certiorari by the Supreme Court of the United States in Davis versus Georgia. Mm-hmm. And I don't know who I should go to. Deirdre, let me just go, if I might go to you first about this, is for a legal question here. Deirdre first and Martina, to the beginning of this case, of what happened, to give people an understanding and the lay of the land here. Let me start legally with Deirdre O'Connor, then go to Martina Correia to talk a bit about that as well. Deirdre?
Oh, well, thank you. There was a shooting in Savannah in 1989 that occurred in a dimly lit parking lot late at night and was resulted in the deaths of an officer and an assault of a homeless man. We know that the whole incident started by a person named Sylvester Red Coles hassling a homeless man for his beer. When the man refused to turn over his beer, Red got angry, and Red is, according to witnesses, known to carry a weapon, usually a .38 caliber revolver. Got angry and said, "You don't know me, I'll shoot you." Within seconds of that, Young was pistol whipped and Officer McPhail was shot. At trial, there were a number of witnesses that came forward and identified Troy Davis as the shooter, despite the fact that this was a case, if you just follow the logic of it, that seems more plausible to be Red that would have pistol whipped Young and shot Officer McPhail. The issue from my perspective with this particular case is to examine the underlying reliability of the original trial evidence, and I think that's one aspect of the case that hasn't been discussed a great deal in the media, and I'm hoping that this will be an opportunity to do that. In any event, there was a trial. He was convicted in 1991. There was a direct appeal by the same lawyer who tried the case, and there are many who have examined the trial record and find that representation lacking. There was a problem with receiving any representation from 1991 through 1996 because the Resource Center in Georgia was had funding issues. They were severely cut. 70% of their funding was slashed. And essentially, Troy was unrepresented until 1996. After that period of time, the witnesses the attorneys began to work the case and discovered that what in fact seems to be the case, that the evidence received at trial was unreliable. The witnesses recanted their statement, and since that time, the attorneys working on this case have been trying to get a court to look at the evidence, and they've been unsuccessful in having any court examine the evidence thus far.
Try to read through as much of your brief as I could in the last couple days, and read the recantations of the witnesses, and read what you wrote in your conclusion. I just legally, I mean, how could this happen? I mean, how could the possibility that how could an innocent man be put to death, or somebody who may be innocent put to death, without anybody in the legal system saying no? I mean, I just get a little shocked by that they will not give him a new trial on the basis of the new evidence.
Well, You're right, and unfortunately, you shouldn't be shocked because it's happening all throughout our country. What we know now with the 222 DNA exonerations is that the innocent, once convicted, have an extraordinarily difficult time getting their evidence of innocence heard. And I really want to spend a moment talking about the reliability of the original trial testimony here, but if you look at Professor Brandon Garrett's article, Judging Innocence, it chronicles the struggles for many of the 222 DNA exonerations. They had to fight tooth and nail to get the DNA evidence, and prosecutors were resisting it, and the courts were very ineffective at dealing with claims of actual innocence. And so you'll see people incarcerated for decades who are factually innocent of the crime, and we don't have in our system an effective way to deal with that problem, and we know it to be a problem that's no longer subject to dispute. In this particular case, what hasn't happened and what needs to happen is an examination of the reliability of the original evidence offered at trial. You've already mentioned there was no physical evidence tying Mr. Davis to this crime. What was used to convict him was a group of eyewitness identifications, which eyewitnesses on a good day can be problematic, right? A well-intentioned, honest person can make a mistake. But these witnesses were subjected to so much more than that, and they were vulnerable to these police pressures. But if you just look at the circumstances, you can see that what they reported initially was entirely implausible and unreliable.
I'm sorry, Deirdre. Finish what you're saying. I apologize. Go ahead.
Dorothy Farrell, for instance, she was standing 160 feet away looking into a dimly lit parking lot at 4 male strangers, all of the same race, and from that distance, completely indistinguishable. There is no way she could see the face of the shooter or any of those men in the parking lot that night to allow her to make an identification some 10 days later.
Can I ask you a quick question, Deirdre, about that, and then we'll turn back to Martina and get to some callers in here before we have to end the hour. That when Spencer Lawton writes in his response to the denial of certiorari in the Supreme Court in Davis versus Georgia, he wrote in here that the law is skeptical of post-trial newly discovered evidence, and kind of accusing the defense of having these recantations of 7 to 9 witnesses obtained by coercive tactics. I mean, accusing the defense of using coercive tactics.
I know, that's quite interesting considering what each of the witnesses are saying. When these witnesses were at trial and they were giving their closing argument, the prosecution was giving their closing argument, they went to great pains to emphasize the fact that these were independent witnesses, independent from one another and independent from Mr. Davis. In other words, they had no reason to harm him. They had nothing, they were doing what a good citizen would do. And now that he no longer needs these witnesses and they're not saying something that helps him maintain his conviction, suddenly these witnesses are easily manipulated by defense lawyers, despite the fact that there's not a single shred of evidence that there's been any manipulation, pressure, coercion, guilt, or anything imposed upon these witnesses. These witnesses have been struggling with their conscience for all these years and have been worried about being charged with perjury for coming forward and telling. He ended up getting the courage to tell the story. But you have one witness after another who is completely unreliable. A man was at the scene, could not identify the shooter that night or months later, well after Mr. Davis's arrest, and he comes into court 2 years later and says that's the man, definitely sure of it. I mean, that's ridiculous, and yet that's what this conviction is based on. And until we get the courts to look at the underlying evidence offered in this case, Mr. Davis is not going to receive justice.
So we're